the champions community for bringing in your beautiful energy, inspiring training.
Oh my gosh,
And so we want
so
to thank
much.
you from our bottom of our heart. And we know it's not the last.
No, I know. So
You're coming back.
thank you so much.
Yes,
It's
thank
lovely.
you. Yes.
It means a lot.
Out there.
Yes, thank you.
Yes,
thank you,
we appreciate you
champions.
so much.
Thank you. Thank you so much. I love that. Well, thank you. You know, that's so rewarding in many ways. You know, because this is our last of our mastery series, right? Which I know we'll put together something in the future, but in my over 30 years, right? Actually 35 years, I think this is the part of our industry as far as trainings, you know, talking about forms and contracts. It's not the exciting thing to do, right? But it's so important, right? Because once you master the contracts and the forms, it just makes, right, your transactions so much smoother, and your conversations with your clients and your conversations with other agents, right? So much better and more effective. So because that just happens to be my specialty and what I have a passion for, you don't see it a lot, right? And I don't know, and I don't blame a lot of my colleague brokers that that's just not their thing, right? But it's definitely mine, and so that means a lot to me, because that's what I get joy out of, is seeing agents benefit from knowledge and from education. So thank you.
And it shows. There's definitely your energy, you know, to do this. And,
thank you. I appreciate that.
Thank you.
So the last class in our mastery series is the buyer broker representation. Well, buyer representation and broker compensation agreement, the BRBC. All right. So I got to tell you, this form actually has been around a long time, years. Okay. In my practice, even though I was probably if I look back, and even now today, when I do transactions for my past clients, I'm still about 50-50. I think I probably do 50% listings, 50% buyers. And even throughout the 30 plus years, I never used a buyer broker agreement. Okay, but like I said, it's been there.
Mm-hmm.
So, and I had a lot of really great agents that I worked with that did. They actually have in fact, that was part of their business plan, right? Was like, anytime I work with a buyer, I'm gonna have them sign a buyer broker agreement. I didn't happen to be one of those buyer agents. And then 2 years ago, everything changed, right? 2 years ago, as a result of the NAR settlement, realtors nationwide, okay, it wasn't just California, realtors nationwide were impacted, and then required, because as a result of that settlement, required to have a written agreement. But that was just realtors, right? So if you were working at that time, which I happen to occasionally, if you were working with a non-realtor at that time, they weren't bound by any settlement, right? They were, because it's not a requirement that you're a realtor. It is if your broker is a realtor. But I just want to make it really clear that 2 years ago, it only impacted realtors as a result. But then in January of 2025, California actually did make it, right, law that in order to work with a buyer, if you're a real estate licensee, you do have to have a written agreement with that buyer. Okay, so because of that, and that impacted now every licensee, it didn't matter now if you were a realtor, if you had the title of or a membership of as a realtor, that didn't matter, and it impacted all transactions. Okay, the only one to this day that is not impacted are leases. Okay, so here we are, now fast forward, right? And now we are required to have a written agreement with a buyer that we are working with. And that is as soon as practicable. Practicable is actually the word, believe it or not. And that's been determined to be before you open a door. Okay, because before you show, and the MLS actually, right, requires that as well. So before you show property, you are expected to have this written agreement. Okay, so like all of our mastery series, we always start from the top. So this BRBC is non-exclusive. That's the very first thing that I want to emphasize. Okay, up at the top, if you look right under the title of the form. Okay, so we are working with a non-exclusive contract. Now you can modify that. You can make it exclusive, but there's two important steps that unfortunately I've seen one step done, one step missed, which makes it what? Non-exclusive. Even if you intended it to be exclusive, if you don't complete those two steps, which we're going to talk about, it's going to default to being a non-exclusive agreement. Okay. So we always say date prepared, right? It has nothing to do with date signed. It's simply a reference date, and it is literally the date that you're typing this contract. Okay, right to represent, make sure you have your buyer's full name. Are they a corp? Are they an LLC or a partnership? Well, that's going to matter, and I'll tell you in a minute why. But if they're just if they're individuals, right? Then there's some very important caveats to that to the contract. And again, it's a non-exclusive right. So now, just like the other core contracts that we talked about, RPA and RLA, all the terms now are in a grid. Okay, like you see the grid here in paragraph 2. Okay, so now we're going to talk about the negotiating terms, which is what we have here. When you're talking with your buyers, these are the details, right, of the transaction, the contractual terms. Okay, 2A1, your representation period. This is the part that is impacted if your buyer is an individual. So if they're not a corp, if they're not an LLC, then there's a cap. What does it say there in the bold? And I probably can't get away from the little zoom, but the little zoom side. But it says buyer and broker agree that if a buyer is not a corporation, an LLC, or a partnership, the representation period shall end on either the ending date specified above or 90 days from the beginning date, whichever is sooner. Okay, so we have a 90-day cap on our BRBCs. That's the point when we're working with individuals. Okay, if they're an entity, there is no cap. Okay, so if you're working with like an investor buyer that's a corp or an LLC, then the 3 month or the 90 days doesn't apply. Okay, but on individual buyers, it's going to be 90 days. Now the question that always comes up is, well, can we extend it? And then the answer is yes. How long can you extend it for? 90 days. Okay, so as long as we just remember that 90 days. Okay, A2, it's going to default again to the type of representation. It's non-exclusive. And here's now the requirements. If you want to make this exclusive, you check that box where it says or. You would check exclusive, and then it even reminds you on top of that, it says valid only if checked. And so that says it's now saying not just check it. There's two things. You got to check this box and initial in paragraph 15. If you do just one without the other, it's not an exclusive contract. Okay, it's going to be non-exclusive. So now we get into the property. This contract actually does apply to all associate licensees that are working through the broker on behalf of the buyer. But because we've had some issues and and it could pose a problem. We always recommend, even if you're on a team, right? That's like usually when this comes up, is you're gonna still wanna have, like, if there's a specific team member that's working with the buyer, you can even add them on, right? With a AAA form, an additional agent, form. The point is, whoever's gonna be working with the buyer, we wanna make sure that they are the ones that have the contract, with the buyer. So B1 is property type, single family residential, but look, you can add, right, a few other property types. You can do multifamily, you could do 5 or more, industrial, vacant land, commercial, tenancy in common. Now, this is the key. You could actually have a BRBC, because this gets asked a lot, for different types of property. In other words, the client that I'm working with, might I maybe have a different fee for my services if it's new construction? That's probably the most common one. Maybe. Well, first of all, we know that there are some builders that offer, right now, I think I just saw one that's offering 4% to a buyer's agent on their track, on their subdivision as a promotion. So on a new construction, right, you might want to have some different terms, right? You don't have to just have it all locked into one agreement. Why? Because when we talk about, when we get to E1, I'm going to explain why that's going to be important and why you might want to do that. Okay, B2 location. Let's not leave that blank, right? Because that actually is one of the requirements to make this an enforceable contract. Is we need to be very specific and make sure our buyer understands what our services are and what we're going to be doing. So where are we located, right? You're hiring me, Justin's hiring me, for example, right, to locate property for him. Where? Is it anywhere in the whole state? Or, right? Is it maybe a county, a specific county, cities? Maybe it's specific communities. Maybe he's very specific. He only wants, right, Chapman Heights in Yucaipa, right? So that's where we want to be specific. And you don't have to be, right, like you can have multiple counties, you can have multiple cities, but the point is you don't want to leave that blank and you don't want to be too broad, right? So if you can be specific, that's better. Okay. B3 is some additional description, like, again, maybe a certain community name that buyer actually is looking for. C, buyer preferences and priorities. There's a BIPP form. It's not often used, but when you pull it up and you look at it, it's actually pretty good. It kind of like takes this paragraph and blows it up, and that's where they can, like, maybe they only want a property with a swimming pool. Okay, maybe the BIPP, like it's almost like a checklist, and they can identify certain preferences on the properties that they're looking for. D is properties excluded from representation. Do you notice too, and I know I've highlighted this in our other mastery classes, next to each the first column, there's a second column, and that's the paragraph number that it's referencing. Okay, so like right now, when I am talking about properties excluded from representation, that's talked more about in paragraph 7. Okay, do you see that? It says D and then it says 7. So it's telling you if you want more information on this specific clause, we can find that in paragraph 7. Okay, and that's what we're going to talk more about, why this isn't just to be, we can pass that, skip it. And you'll see why when we get to 7. Okay, broker compensation, E. On all of our contracts, right? It says, notice the amount or rate of real estate commissions is not fixed by law. They're set by each broker individually and may be negotiable between buyer and broker. See attached BCA, the compensation advisory. Always negotiable, right? That was also very emphasized as part of the settlement. Always negotiable. E1, amount of compensation. So what is my fee for my services? And I think we might say, well, it depends, right? We don't have to have a blanket fee for everything. I mean, this contract, when we went over the term up at the top, right? We said it maxes at 90 days, but we could make it for one weekend, right? I mean, if a buyer, especially for buyers that may be reluctant or hesitant, right, to get locked into with a certain agent, it's kind of getting to know each other, and you could easily say, okay, well, let's do that. I've separated or I've allocated 5 properties, right, to show you over the weekend. And sometimes you have to adjust, right? These contract time periods. So that might be useful. So if the client also comes to you with a property, Gina, I already found the property, right? Especially with past clients. That's why I love past clients. Okay. And they're like, I found this property, right? I wanted to write up the offer, da, da, da. So again, the point about the fee is that might depend, right? Are we looking at a client that's, properties that they're looking for only come up it's very rare. It's a hard to find type property. So you have to allocate your time, your energy, right? All of your expenses. Well, that might reflect in your compensation amount. The point is what you charge your independent contractors, it's your business. Always double check with your brokerage if they happen to have any policies. But I'm just saying contractually and generally, that's going to be something that you base off of your basically your business plan. Okay, E2, payments received by broker from seller or others. So I've established what my fee is in E1, whatever that is. It could be a percentage or a dollar amount. But any amount that I get from a seller or from others will be credited, okay, towards that amount. That's what E2 says. E3 is the continued right to payment for broker-involved properties. Huh, interesting. Okay, E3, we don't want to leave that blank. What is that? So the continuation period, let's just say we put 60 days. I'm just going to use that as an example, okay? So that it would read, the continuation period shall be 60 calendar days after the following. If this agreement is not canceled under paragraph 5, the end of the representation period, so whatever I put up at the top, right? So if I put 90 days, okay? So it's saying that there actually is going to be a period of 60 days that I might be entitled to compensation, even after the expiration, the end of it, okay? Or if this agreement is canceled under paragraph 5, the effective date of that cancellation. So there's an opportunity of 60 days, there's a 60-day window if I put 60 days. If I left it blank, then this doesn't even apply at all. But what we're going to learn in 4C is there's an actual time period. So like, let's just say, right, I'm working with the buyer, and let's just say my contract ends today, right? Today's the 90th day. And they actually go and make an offer and get the offer accepted on the property that I actually showed them today, right? Tomorrow, I don't have a contract anymore, but they go and they make the offer and they get it. Well, if I didn't put anything in my continuation period, I'm not entitled to compensation because my contract ended today. Okay, but if I continue the contract by 60 days or whatever amount of days you put, just don't put more than 90 because everybody freaks out if there's ever anything more than 90 days. Okay, then 4C tells us there's a chance. Now, not automatically, there's something very important that we have to do in order for that to kick in. But the point is, don't leave that blank. E4, if I'm paying a referral, even Zillow for this buyer, okay, we have to disclose that. We check the box and it's going to pull in the RAD form. Okay, so now all referral fees have to be disclosed. That's what the RAD form is for. 5, cancellation rights and notice. This contract, any BRBC, not like a listing agreement. Remember, we talked about the listing agreement at our last session, this is very different. In fact, when in the RLA session did we ever come across a paragraph that said cancellation in a listing agreement? We don't. There is no paragraph in a listing agreement that says cancellation. Okay. So what that tells you, and I think the reason why maybe it'll change one day, is because that contract cannot be unilaterally canceled. The listing agreement can't. Okay, it has to be canceled. Both parties have to agree to cancel it. Not this. Okay, the BRBC can absolutely be canceled, and it's really not that difficult. On a non-exclusive, which didn't we just say this defaults, non-exclusive? Cancellation is effective upon receipt of a so I can just, Justin could just email me and say, hi, Gina, well, thank you very much, for working with me, but I want to go ahead and cancel our BRBC. And when I receive that this contract is canceled. That's all it takes. And it can work either way. Either party may do that. Okay. On an exclusive, it's still not that big of a challenge. It's actually effective 30 days after receipt, even on an exclusive. Okay, so let's make sure we understand that these contracts can be canceled, but those it has to be in writing. Okay, now we're getting into buyer financial and personal information. So we want to make sure that our buyers are qualified, which I think we pretty much do that, right? Before we go out and show property, I think we're pretty good at making sure they're pre-qualified for a loan, financial, right? Financially, they have the down payment, the closing costs. And so this kind of reiterates that in paragraph 9, but it's very clear here. We got 5 days to make sure, right, that the buyer has delivered to us their proof basically of qualifying. G2 is, what if the buyer doesn't have whatever fee I put under my compensation, whether it's a percentage, whatever I put there, what if the buyer does not have sufficient funds to pay? That box would be checked right there in G2. And then it says buyer's broker's obligation to represent buyer in a transaction is contingent upon a seller's agreement to pay the amount of compensation. Okay. So if you're working with a buyer and they've made it very clear that they understand this is your fee, and this is really what this is. This is a disclosure of my service, of my fees, right? For my service. Every buyer that I work with has to sign it because this is what I charge. That doesn't mean that they're in agreement to pay, physically, literally pay it. Well, that can be negotiated, right? We know that we can try to negotiate it in the RPA, but there are times where a buyer simply doesn't have the money. Like they don't have the money for the closing costs, the down payment, plus my commission. Okay, so we got to make sure it's very clear. We would check that box off, and then paragraph 9 talks more about that. H is other terms. Maybe some on other terms for a buyer, maybe there's something specific that the buyer, again, we can add what if I'm the agent, I'm also the buyer. The brokerage is going to still require, and there's nothing in the law that says you don't have to have a BRBC. So, right, I could be buyer, agent is also buyer. I still have to have a contract because the contract's with the broker. Okay, advisories on 3, 4 compensation. So remember the grid, we're out of the grid now. Paragraph 2. Okay, so we're no longer in the grid, but now we're in those paragraphs that the grid references, right, on the second column. So for example, right here in 4B, it talks and it breaks down a little bit more about the exclusivity versus non-exclusivity. Okay, so if you look at B1, which it defaults to, non-exclusive representation, broker involvement. Okay, so that's going to come up. You're going to see, we're going to talk right here in number 4 about broker involvement. So compensation in that case is payable only if there's broker involvement on a non-exclusive. Well, look at B2, exclusive. If the exclusive was checked, and initialed in paragraph 15, then broker's entitled to compensation if buyer acquires property during the representation period or any extension with or without broker involvement, even if another broker is also entitled to be paid for representing buyer. So that's the key difference between a non-exclusive and an exclusive contract. Okay, exclusive, there doesn't have to be, there's no requirement of broker involvement on a specific property. It's like a relationship, right? If you're exclusive, that's what it is. Exclusive means you weren't gonna go, right? Look for the services of anyone else. So non-exclusive is no, right? You can, in fact, a buyer can have 2, 3, 4, 10 BRBCs with agent, all non-exclusive. There's nothing, right? Now, broker involved, now that, what gets the agent paid in the case like that? Broker involvement. So let's see what broker involvement includes. Well, first of all, in B3, just so we know, buyer, this has actually come up a couple times. It actually, when we reference buyer, there in B3, it actually does mean any person or entity. So like, even if, right, the contract maybe was with, with Justin as an individual, but yet Justin ends up making an offer through his corp, it still covers it. Okay, because it's his entity, it's his entity. Related, or if they're related to the buyer, or who in any manner acts on buyer's behalf. Okay, so it kind of like is broad in that sense, and that's actually come up before where it's helped. Somebody goes see the property, the mom actually ends up being the one that makes the offer, and then the agent feels a little right? Like, hey, well, I got X'd out just because the mom ended up making the offer, but my contract was with the daughter. So we were able to get some protection because it's related to buyer there on that phrase. Okay, 4, broker involvement. So what does this mean? Because we just said that even if it's non-exclusive, right, which is what it defaults to, if there is broker involvement, that's the key to getting paid. Okay, well, buyer physically entered and was shown the property by the broker. And this is any of these, it's not all. It's if any of these apply. Broker showed the property to the buyer virtually. Broker submitted to seller a signed written offer from buyer to either acquire it, lease it, or otherwise acquire it. Broker performed a market analysis related to the property or reviewed property specific documents or disclosures with the buyer. The property was introduced to the buyer by the broker or for which broker acted on buyer's behalf. But merely just sending a list of properties, like if they're all like on a hot sheet or one of these auto send type of things, there has to be documented action on the part of the broker for analyzing that specific property, okay, for the buyer, or assisting the buyer in the potential acquisition of the property, or communicating with seller or seller's agent regarding buyer's potential acquisition of the property. Okay, that's what gets us our compensation on a non-exclusive. Okay, there has to be one of those. And then the buyer assignment, this is actually new. This buyer assignment paragraph, this came out in the June 2026 release because there wasn't anything identified regarding when buyers assign the contract. So if you work with wholesalers or investors, that was an issue, okay? Because we would get under contract with an investor, and then they would end up locking in the deal, opening escrow, and then they would assign it to a third, right? Some random other corp. And then we were like, wait, what? So now they have the assignment clause in this contract, which is helpful. Remember that continuation period? So that's where we're at right now on C. You don't want to leave that number of days blank. So let's just say for illustration, we were using 60 days as an example, but you can put your number of days up to 90. Broker shall be entitled to the compensation that we said over on in paragraph 2. If during the continuation period specified into E3, buyer enters into an agreement to acquire property for which there was broker involvement, Okay, the timing of such payment is subject to the terms of 4D. Broker's right to compensation pursuant to this paragraph, this is the key. I'm there in C2. Shall only apply if prior to the expiration of this agreement or any extension, broker delivers to buyer written notice of properties for which there was broker involvement. That's the only way that 60 days that we use as an example kicks in. You have to deliver a list of the properties that you actually showed them or you did anything that we read, broker involvement criteria, and you do that using the NBIP form. It's the notice of buyer or broker involved properties. Okay, if you don't do that before the expiration, you can't do that the day after. Has to be prior to, right? Or it says no later. It says prior, actually, prior to the expiration or an extension. You got to deliver that list, and then your continuation period is protected. Okay, it's locked in. D, timing of compensation. Well, we know just like the listing agreement is going to be upon completion of any resulting transaction. Yes, there's a way for default of buyer and that, but that's where you start getting into needing your management involved if you're going to try to pursue that. Payment is through escrow. This can actually be submitted to escrow as a demand. F, accounting for payments. Remember I said that, well, in this case, actually, if you also represent the seller, there's to be no confusion. Remember we said that? It's completely separate. Whatever your commission is on a listing agreement, you're not going to somehow credit here, right? Make any sort of credits from your listing commission to this agreement. They are two separate agreements. G is your payments received from others. Now, this is the part where you can really get into these conversations with your buyers about how does this work, right? How does the whole payment of this commission? So we're going to discuss here, like G1 says, discuss with the buyer. Is it beneficial to include a term in their offer that buyer makes obligating the seller to pay my fee as a broker, right? Directly or for some or all compensation. Maybe it doesn't have to be all of it. It could be for some of it, right? In G1, for some or all of the compensation. So if my contract is whatever percentage, maybe the buyer's like, well, you know what? I really want this house. Instead of asking the seller to pay the whole thing, how about half? Oh, okay. That's good. Sure, we can try to do that. If seller does not pay as contractually required, then buyer assigns to broker, right? What's called a third-party beneficiary. 3, under a settlement agreement. Didn't we just talk about that? Under a settlement agreement binding on realtors, brokers prohibited from receiving compensation for broker's representation of buyer in excess of the amount in this agreement. Buyers advised not to include in a purchase offer a request that seller pay a higher amount unless amended prior to buyer making the offer. Okay, so we're going to want to make sure what it's saying is that if our contract is for X percentage, we're not going to now try to have the seller, right, or request that the seller pay more than that. That's very important. And then again, if we're going to receive a referral, we're going to want to complete the RAD form. And of course, there will be a disclosure to the buyer as far as what the final compensation makes. That's actually through their closing statement. Okay, 5, cancellation. Remember we said it's actually not that, right? It was upon notice on a non-exclusive. So it says in 5A, either buyer or broker may cancel this agreement by giving written notice at any time. Right? 5A, at any time. That means like the next day even, unfortunately, right? If that's what they wanted to do. Make sure they give it to the other party, right, within the time specified in paragraph 2F. Broker shall still be entitled to compensation if what? If during the representation period or the continuation period that we got locked in, right? If the buyer enters into a contract to acquire property for which there was broker involvement. Provided broker delivers to buyer, what did we say we have to deliver? A written list of those properties for which there was broker involvement. The written list of broker involvement properties shall be delivered to buyer within 5 calendar days after the effective date of the cancellation. So this is different. This is now with cancellation, okay, in order to protect. The other one was prior to the expiration, remember? So you want to deliver, if it's prior, so like if it's just a buyer where, you know, your contract expires maybe tomorrow, you're going to want to deliver the list, right? It expires. Maybe you're trying to work out an extension on it, but you're not sure yet. But this is cancellation. Okay, so on a cancellation, it's a little different. Make sure you deliver that within 5 days after the effective date of the cancellation. Buyer's advised to notify any other broker rights under this paragraph, which we'll talk more about in a upcoming paragraph. 6, agency relationships. I think we're really good. The AD forms, the disclosure of agency or confirmation of agency relationships is included. The AD forms included, it's bundled with this actual contract. Possible dual agency with seller, okay. That can only be done, right, with full consent. So the PRBS helps you with that. But the agency is always confirmed in the purchase agreement. Paragraph 2 is where agency actually gets confirmed. The termination of this agency actually happens upon either the expiration or the effective date of any cancellation or upon completion of this transaction, whichever occurs first. Properties excluded. Now, remember I said over in the grid that we don't want to just have it, we don't want to just skip over that. Why do we want to actually potentially exclude properties from this contract? Well, this paragraph talks about when you would want to do that. If the buyer happened to already have a written agreement with another broker, didn't we just realize that they could also be entitled to compensation if they had, right? Perhaps a continuation period as well. So it's really, really clear here. And these are the conversations that we want to have with our buyer. We want full disclosure. Look at A2. Buyer shall disclose to broker if another broker showed buyer, right? Either a specific property or if they were working with another broker. Look at 3. If buyer has signed an exclusive buyer representation agreement with another broker that has not expired, then buyer may owe compensation to that broker if buyer purchases such property, even if that other broker had no involvement with the property. Buyer shall disclose in 2D, which was where I said excluded properties, any property for which buyer is obligated to pay another broker. That's super important. Unfortunately, we sometimes don't get pulled in until there's an issue, when if we would have just dug a little bit deeper with the buyer in these type of conversations, we could have probably identified that from the beginning. That could pose why? Conflicts with the other broker, right? Because if they happen to enter into a contract as a buyer, it says right here, right? Well, we want to make sure to exclude it. And then look at why? Because look at the limitation on C. Because if a property is excluded and during the time buyer's obligated to compensate another broker, meaning us ourselves are not obligated to assist the buyer with respect to that property, even if we have this contract. Okay, buyer shall not owe broker compensation under this agreement for that property. Better to address it now. If they end up owing another broker, we're not obligated to represent them on that transaction. Okay, broker authorizations and obligations. Does anybody here have a buyer presentation? Like maybe like a template buyer presentation that you might automatically share with potential buyers? If you don't, and even if you do actually, make sure, I think this is really well, it's so simple that I like it. In 8B, this actually breaks down when I talk about our services as a buyer's agent, what we're going to assist the buyer with. Okay, so I think this fits really, really nicely in some sort of buyer presentation. Because that comes up a lot, right? Like, well, first of all, why should I hire you? What are you gonna do for me? And you can, make that look very nice, very elaborate, but make sure it identifies at least the basics. Right here, right? Locating, presenting property, selected properties, any of the offers, assist in negotiating those offers, right? Facilitating the escrow process. As directed by the buyer, we can order reports, investigations, schedule, attend meetings, appointments with professionals chosen by the buyer upon request, providing buyer with a list of professionals, right? I have a list of professionals that I've worked with over the years, buyer, who can help you. Okay, upon request, assist the buyer with the financing process by making referrals to lenders known to the broker, assist the buyer in obtaining the loan pre-qualification to the extent that we can do so. Okay. We're also going to conduct a diligent visual inspection as well. We're going to communicate to the buyer all disclosure material information received, right, during the representation period. So just something really helpful if you don't already have something. And then what's the buyer going to do? They're going to act in good faith. Okay. They're going to act in good faith to timely view the properties that I've dedicated as part of my service agreement. And they're also agree to negotiate in good faith to acquire a property and work in good faith towards the completion of any contract. Remember that financial and personal information paragraph that we talked about where it says if buyer does not have sufficient funds to pay, right? We were going to check off that box, and then it said, now we're going to refer to paragraph 9. Well, this is paragraph 9. So this is what talks about if the buyer is not expecting to pay our compensation. So what happens in that case? Well, within the time specified in 2G1, remember the contract gave them 5 days to provide their personal financial information, which is proof of funds. That's kind of like a general, like, I want to make sure that if we're looking at homes within the 700 to 800,000 price range, it makes sense, right? That we would want to make sure that you qualify and that you're able to purchase a home within that range. So that's what B1 covers. B2 is the box. So if that box was checked over on page 1 that said the buyer does not have the funds to pay my commission, then it says for any property for which buyer writes an offer, this is what has to happen. 2A and 2B. 2A says buyer agrees to include a term in the buyer's offer requesting seller to compensate buyer's broker. Okay, so if you're not able to pay my fee, then we need to include a term in your offer for the seller to compensate buyer's broker. And then B says, for a transaction, this agreement is contingent upon seller or others or both agreeing to pay broker the full amount that buyer is contractually obligated to pay broker. This contingency is in favor of the broker. It's very transparent. Okay, this is a contingency in order for us to work together, because you're not paying my fee, then the only way this is gonna work, right? It's a contingency in my favor, is we have to get the seller to agree to it, right? Broker may elect to cancel this agreement related to representation on that specific property if the seller does not agree to pay the full amount that buyer is contractually obligated to pay broker. Broker shall inform buyer, seller, and listing agent. So this is right. It's very specific. It's telling us, what do we do in these situations? Gina, what do I do in a situation where I've made offers and the seller the seller has come back and said, I'm not going to pay you. I'm not going to pay you. I'm not going to pay you. Well, then it says, I shall inform the buyer, the seller, and the listing agent that buyer is proceeding without representation and that they shall complete a new agency confirmation, removing broker as representing the buyer. So that's what happens. Are you obligated to work for free? Do you have to work for free? No. Okay. The contract says that if you cannot get the seller to pay the compensation, then you basically step away. But you have to inform, right, buyer, seller, and listing agent and that's only if the buyer is proceeding, right? Like if the buyer's like, oh no, they're not gonna, I want you to represent me and I want to find a property where you're able to represent me. Well, that's different. But if the buyer's like, well, I still want the property, I'm sorry, they're not gonna pay you. I still want it. Yeah, well then, the contract tells us, well, this is what this is what we do. Okay, C, reasonable care and other professional assistance. Of course, buyers should always read all documents, right? They have there's a buyer's investigation advisory that kind of prepares them for what to look for, right? Maybe concerns that they may have when it comes to the actual property itself. Buyer, if they do want a specific report in advance, but that's usually more for sellers. But if they do, then they're going to have to pay for, right, those reports. Buyer material issues. That's actually similar to the buyer preference form. But if there's a specific issue, like they want us to think of like the buyer preference form as a form where they list their preferences, right? Like swimming pool there. This is actually like kind of the opposite. Like this is where they're saying material, like I absolutely don't, like this would be considered a material issue for me. Very rare, but obviously you want to make sure, right, any of those issues are addressed. Incorrect or incomplete or inaccurate information, we would be held harmless for that. Attorney fees are a prevailing party. Management approval, management will have 5 days if they needed to cancel this contract for whatever reason. Dispute resolution, just like all of our other forms or contracts. Mediation, if there's a dispute between a buyer and a broker, they both agree to have mediation, have the matter heard or disputed through a mediator. If it's a small claims action, like in B, small claims is exempt. Does anybody happen to know what the updated small claims amount is? It actually went up, I want to say last year. I think it's 12.5, right? Yeah, 12.5. Okay, so any matter under 12.5 can now be heard through a small claims action. Legally authorized signer. I know we talked about this before in our other classes. Same thing though, with a BRBC. If the buyer is a entity, okay, which is what? Corp, LLC, trust, probate, power of attorney, trustee, okay? We're gonna want the evidence of authority showing that we are actually dealing with the legally authorized representative or signer on behalf of the entity. Okay, this is the entire agreement. If there was any oral agreements, even if it had to do with, you know, compensation and so forth, this would actually prevail any prior oral agreement. Now, remember the two-part requirement for exclusive? Remember the first step was you got to check the box. And then it said, and initial in paragraph 15. So unfortunately, sometimes when we come across this and the initials are missing, that's a problem, right? But what happens here, this is just, again, another, to reiterate the exclusive part of a contract. A, the agreement shall be exclusive. Broker will devote time and resources to assist buyer in finding and acquiring the property in the expectation of being paid for broker services. Buyer shall not enter into another representation agreement in conflict with this agreement. Compensation, brokers entitled to compensation if buyer acquires property during the representation period with or without broker involvement. Remember, that's the key factor, right, of exclusivity is it's with or without broker involvement, even if another broker is also entitled to be paid for representing buyer. Cancellation, if either buyer or broker, they actually may unilaterally cancel this agreement by giving the other 30 days written notice, or if you specified a different time frame, you just can't, it can't be like effective, right? It has to be 30 days. If within 5 days after the effective date of the cancellation, broker provides buyer a list of properties for which there was broker involvement, broker may still be entitled to compensation if buyer purchases one of the properties on the list during the representation period or the continuation period. So exclusive, how many of you actually only work exclusive, or do you keep it non-exclusive? No, yeah. Yeah, okay, yeah. I always, okay, yeah, I hear, yeah, usually when agents are like, no, I've been burned a lot of times. So exclusive is usually, yeah. So that makes sure, right? And you guys already know then you need those two, the box checked and the initials. Now here we're at the signature portion. So remember the RCSD form, which was the representative capacity signature disclosure? The form still exists. But if you complete this, like it says here, entity buyers, no, if this paragraph is completed, a representative capacity signature disclosure is not required. Okay, for the legally authorized signer just designated below. So if we're working with an entity, let's try to get this completed right, in full, so that you won't need a separate RCSD form. And then buyer signs here. We still only have 2 signature lines. But like the paragraph says, if you need an additional signature, just use the ASA form. Broker signature here, you got 2 lines, so for 2 agents. If more than one agent from the same firm represents the buyer, use the AAA form, or if you're co-representing with a different brokerage, that's fine too, but you're going to want to make sure to use the additional broker acknowledgement, which is the ABA form. So that actually is the buyer broker representation agreement. Do we have any questions?
One.
Yeah.
And this might be a silly question, but it came to my mind, so I'm gonna ask it. So on the one where the seller was not willing to pay for the compensation.
Oh,
and
yeah.
We're not gonna work for free.
Yeah.
So say the buyer goes and gets another agent and they get paid a portion of it, maybe not what we were asking, let's say they got 1% versus the 2 or the 3%.
Yeah.
Are we, because we showed them the property we're involved, we're entitled to that compensation?
On a exclusive or a non-exclusive? Because that's always going to be the first question, right?
Well, both.
Okay, on a non-exclusive, we would have to provide them with what? The list, right? So if they're provided on the list and we, then you're protected. Now, being entitled to compensation and actually collecting it are 2 different things.
Right.
Because I've had a lot of very like actual legitimate, right? Like you're legitimately entitled to it,
Right.
but now the whole pursuing of it is completely different.
Yeah. We could go to small claims.
Sure, yeah, that's
It's
right.
gonna be in
That's where the small,
claims.
yeah. That's where if it's under the 12.5, right? That's where the small claims comes in. So yes, yes, always provide the list. Yeah.
At the beginning, you said, for investors, we can put more than 90 days or?
If they're a entity. So if the investor is a corp, an LLC, yes, then the 90 days does not apply. You can have a contract for a year if, yeah. Mhm.
Okay, for every offer that we're gonna submit, in different properties, do we have to update the BRBC with a date, or we just submitted the first time we submit an offer for the client?
Your BRBC is good for multiple properties.
Okay, so
Okay.
we don't have to update it,
No, unless you're,
90 days.
yeah, exactly, then you could do them, but you can actually do a new BRBC, but there's also a modification form. A modification of, so MT is actually the name of the form. So you can use just it's a 1 page, it's super convenient, to extend instead of having to do another one. Yeah. Any other questions? Yeah.
Escrow, that period is
to close it or in the beginning of just showing the property? It's that 90 days, right?
Yes, that actually is to secure an offer. So like, even if you got an offer accepted today and right, and I only had 1 day left, it's because we got the offer accepted within the 90 days.
Accepted.
Yes, yes. So you're good. No, not closing. Because closing, right? You know how that goes. That could, yeah. So that's, yeah, completely separate. You got the offer accepted within the time, the representation period or an extension.
I think you answered my question on this, but like, if you put 3%, but then you open ask for and it's 2% and you're okay with it, you would also fill out the addendum. So
Oh, okay. If you're, yeah,
Yeah,
so
you
if you're
can-
modified, sure,
yeah.
yeah. That would actually be the MT form,
empty.
which is the modification of terms. So you would go from, like, in your example, you would go from 3% to 2%.
Oh.
Yeah.
And then another question is, sometimes I've seen it where we submit an offer and they only want the first page of the BRBC. Are we supposed to give them all of the pages?
I'm so glad you asked that. So a listing agent should never ask you for a copy of your BRBC.
Oh,
Okay, and if you're a listing agent, please don't ask for a copy of the BRBC. Okay, CAR has made it clear multiple times. This is actually it's a confidential agreement, just like the listing agreement, right? This is this actually reveals, didn't we talk about financial information on here? Right? It even has a box that says, oh, buyer can't afford, right? Doesn't have the money to pay me. Why should the seller know that? So we got to be careful what we actually reveal. And it's been very, very clear that the listing agent is not the BRBC police. So they are not entitled to a copy of it. And I absolutely would not provide it.
They
Yeah.
used to, yeah, our attorney told us the opposite. Yeah.
Oh.
Because of the fact, how do you prove that you're supposed to be entitled to 3% in the funds?
But who,
Because on your BRBC, what if you put 1%, but now on the offer, you're asking 3%? This specifically says you do have to provide proof that that's what you pay.
okay, but the seller is not the one that enforces that. That's the key. So yeah, there is for sure the possibility, right, that the agent is asking for more, but never does it put the obligation on the seller or the listing agent to actually verify that. They are not the ones to verify that. They just either agree to pay or they don't. But you can actually, I actually have a name of a few of the CAR attorneys that you can even ask for specifically.
So yeah, so that's even on the checklist.
Oh, yeah, be careful. Yeah.
Your seller can come after us and say, well, we paid 3% and you never asked the agent to pay.
Your seller could come after.
They paid 3% from the BRBC and we said 2%.
Yeah, no, interesting. I've not heard that rationale yet. Yeah.
Yeah.
Yeah,
So
because
that's like,
yeah, no, that's a good point. Yeah, so I have I could look it up. Yeah. Or there's actually even an email too, and they'll actually respond. Yeah. With that. Yeah, but that's actually really, really good. Yeah, you gotta be careful with that.
The listing agent or those BRBC.
You're saying the
Yeah.
now escrow for sure.
Oh, yeah, no, but usually.
Escrow, I've had escrows actually confirm it,
Yeah.
and they'll call it out.
Hey.
Yeah, but I've never, yeah, I could see, right? Because escrow's the one that's like, okay, paying everybody out. But yeah, I've never, in the beginning, I would say 2 years when it started first coming out, I think it was kind of like that. Yeah, there was more of that, but then it came down very, I would say probably about 6 months this way, where it's very, very clear.
Because of the liar syndrome.
Yeah.
Their own protection.
Yeah.
Yeah.
And there wasn't like a lot of clarity because it was so new. Yeah.
And then, yes.
Yeah.
But then it had that.
Yeah. So no, that's a really good point. It's come up in a couple of our industry leader CAR meetings. Because it still comes up often. But yeah, no, double check for sure. That's just the clarity that we've been provided with. And in fact, it just came up like 2 weeks ago in one of our broker meetings with CAR.
So they can't withhold your offer because you don't provide that, right? If you run into that,
Well,
I mean,
that's-
that becomes a big problem.
That becomes a problem,
Yeah.
yeah, that's where you'd have to, yeah, I would definitely escalate it, yeah, to their, you know, their broker.
Well, I know
their
some
understanding.
agents too will say, oh, we can tell you guys, this is
Mm-hmm.
what pays five. And I'm like, well, that's pretty rare.
That, yeah, I've heard all sorts of, I know, I've heard all sorts of different things. That, yeah. I've heard of like, oh, then I'll just submit, when they think that they have, they're like, I'll just submit the signature page. Or like, and I'm like, well, I'm like, I don't understand what, I think this is just getting all too, yeah. But no, ultimately, so with the seller, so this is, the seller doesn't have, is not obligated to pay, right? The compensation to a buyer's agent, regardless of what really the amount is, seller doesn't have to pay at all. It's all negotiated through the RPA, whether they're going to or not. The BRBC is a contract between the buyer and the buyer's broker. It has nothing to do with the seller. It's completely separate, right? If the seller, through the RPA, which clearly the RPA says brokers are not parties to this agreement. It starts off by saying that. So definitely two separate matters for sure. Any other questions? Oh, question on the Zoom, yes. Do I have to unmute or no?
No,
It's on the chat.
It's on the
Chat.
Oh, it's on the screen. Oh, okay. If the exclusive BRBC still active and the buyer goes and purchases a property with another agent, but I never show that property, am I entitled to the compensation? Okay, yeah, so there was no broker involvement, it's still active. Again, your entitlement, yes, the pursuing of it, right, is a separate conversation. But if you're in an exclusive buyer broker, it says, right, if you look at 15, what did the buyer, when they initialed it, what did they actually agree to? They actually said, buyer shall not enter into another representation agreement in conflict with this agreement, right? So no, yeah, you would be entitled to it, again, without knowing all the circumstances, but from just the information you provided, but again, pursuing it to completely, actually collecting it, right, it could be a challenge, yeah.
This might be. What exactly does small claim courts, like, what is the advantage of filing it? Do they have anything that can happen to the buyer? Let's say you're now pursuing the.
Oh, yeah.
Right.
And what was your question about small
Like,
claims?
I don't know, is it like a lien that gets attached to the?
That, I'm not really sure. That's more of like, the court and the legal, I know there's options for settlement. I mean, sometimes they settle right there at the court.
Yeah.
Yeah. Before
It announces the next.
Yeah, and then there's,
Yeah, it's an
On the
abstract
public
judgment.
Profile that there's a claims on the against them. right?
Then they
Is that
have to
what it is?
file a judgment once they get from the court, so if you don't like settle and pay it out there,
there,
then the court will get the judgment, they need to file the judgment against them to
Yeah.
try to collect.
Yeah, it's an abstract
Yeah.
of judgment, and there's different ways you can collect. If you
Oh,
want to
so you
continue,
could
but you get an
still-
abstract of judgment.
But you're saying it's still a process that you don't want to get involved.
well, it's an option, right,
Yeah.
in the contract, if you have to get to that point. Yeah, so the contract provides that as an option.
Oh.
Yeah. Any other questions? No? Oh my gosh, guys, we made it. The end of the master series. Yes. All right, well, thank you. Thank you, everybody. Have a wonderful day.
Thank you.